I'm going to talk you through one of the key readings. It's not that easy, but it is really important in terms of setting a few kind of basis ideas for the unit. So it's the first chapter in Stein, Principles of Planning Law. It's not all that new, which is a little bit problematic in terms of legal material, but because so much of what she talks about is background material, then I think it'll be fine. So I've highlighted the things that I think are important and made notes in the margins. So if you may not need to listen to this, but if you do find this chapter difficult, I'm going to point out what I think is important about it. So planning is that contradiction between the greater good of the community and private property rights. So council or the planning authority, which is usually council, stepping in and saying, no, you can't do that, or no, yes, you can do it, but on these conditions which are needed to preserve the views, preserve people's privacy next door, that sort of thing. It's a juggle. And we know that it's often contentious because if you read your local paper, regardless of where you live, and look at articles around planning and letters to the editor, a lot of it is about contentious developments. So she talks about planning ideology, and I guess this is relevant right from an individual person who has values and opinions about what should happen through to state governments, federal governments. So state government's particularly important because so much of planning happens at a state level. The current Hodgman Liberal government in Tasmania came in partly on a platform of cutting red tape and making it easier for developers to get planning permission. And so a big part of the planning reform that's going on at the moment in Tasmania is around trying to make the system faster, easier, cheaper to navigate. Whether that's actually going to be the case, we won't hold our breath to see whether that might happen. So planning is supposed to produce an improvement in life of people, allow development while retaining all the things that we hold as being important. It's difficult to actually realise this goal because there's a fundamental tension between the legal and regulatory aspects of planning and those kind of public good goals, the goals that are stated in strategies and policies at federal, state and local levels. And so, what exactly dominates is interesting and plays out on an individual basis. So Stein here talks about how in the 1990s planning was very much seen as a battle between local councils saying no and the rights of individual people, and that it was basically a political exercise. You'll see that in some of the other documentation that you're given, particularly the material written by lawyers and people involved in the practice of the legal side of planning, they'll argue that as planning professionals, you need to really understand that legal side of planning, the side that doesn't have to do with politics, because this is where you can get yourself into trouble. You'll see quite a lot in various literatures around the importance of the triple bottom line. So at the moment in Tasmania, there's more of an emphasis on profits, development, jobs, but increasingly controls do encourage that triple bottom line of economics, environment and social sustainability, so ESD. So the concept of sustainability came up in our promises around the Rio Convention and the agreements that came in after that. And so this page puts the case that Australia has signed up to this as a result of our obligations under international conventions and treaties. But that's all very well. The translation of that into planning the day-to-day practice is pretty tricky. So More recently, some of that emphasis on sustainability has changed into more of an new urbanism livability. So this is an area that I'm particularly interested in as an advocate for active transport. So people getting around cities on bikes and buses and pedestrian and various modes of public transport other than private car use. Notions of livability and people-centered places are something quite important to me, but it's really can be quite difficult to embed that in planning. So the highlighted section here, the concept of sustainable development, livability, other desirable high-level goals that we have as a community don't provide decision makers with the kind of detailed and integrated prescriptions that they need to make day-to-day policy decisions. Equally, you could read this as don't provide the kind of legal structures that councils, as the decision maker and judges who are deciding on disputes, it often doesn't give them what they need to make decisions that come out in favour of the community. So regulation, planning is about regulating what people do on their property. It's about what happens on public lands too, trying to make sure that it's for the good of the citizenry. But the values and ideologies of planning that are about that quality of life or sustainability don't fit well with these controls. And we'll work through various examples as we go through. So a policy is something that expresses goals, but it doesn't necessarily map down onto those legal rights and obligations at the level at which decisions are made. So a planner might make a recommendation to aldermen who essentially make the decision that's against what they want to advise, but their hands are tied legally. So this is why some of this legal nitty-gritty in this unit is important. It might seem a little bit difficult, but it's really important in terms of your responsibilities under the law. They talk about an example in New South Wales where, well, this could apply anywhere, where a developer can object to what should be a pretty concrete development standard. But because of the way that the law works, it can be, if they've got a good planning lawyer, it can be surprisingly and perhaps disappointingly easy to object to conditions under a permit and to overcome what should be a pretty rigid standard. So the planning policy of avoiding rigid controls is clear, but the principle that's found in legislation that defines standards is often confusing. Planning schemes are not necessarily written all that well, and so this is where lawyers have a field day in terms of picking out these details that matter and make decisions that perhaps they don't like, that council have made, invalid. So as somebody working in the planning profession, either advising clients or working for council, these things matter. So here's me having a little bit of a rant. A judge is described as saying the shifting sands of words used contrary to their original meaning, indeterminate abstract concepts, vague complex notions that are incapable of ready resolution. That is, unless things are really clear that the same word is used consistently to mean the same thing, like a house is called a house consistently in a document and not referred to in other places as a dwelling or something else, those kind of inconsistencies or abstract concepts, complicated notions, they make it really difficult for a planning authority to hold a line. So ostensibly, Stein now talks a fair bit in this chapter about property rights. I'm going to skip over some of it. But property rights basically comes back to the doctrine that an owner does have the right to do anything with the land, but there is a legal requirement that you're not a nuisance to adjoining landowners. So in the case of, for example, forestry, silting up a neighbouring property's land, that could be a problem. And I know of at least one case where the judge has found that forestry did the wrong thing and the neighbour was eligible for compensation. There's a few keywords coming up that you'll need to know, you'll become quite familiar with. One of those is zoning, and I'll talk a bit more about that in a minute. But this generally is about land use control, is not about taking land without compensation, which is in violation of the Constitution, but about regulating land use for the good of the community. So this is often tricky, where as individuals and groups within the community, we don't necessarily agree about what's good. So decision makers need to resort to what is reasonable, what is common sense, and ultimately make judgments that direct us. Okay, so yeah, this makes it tricky for planning professionals, particularly if you have aspirations around your community looking different, about doing something other than maintaining the status quo. It makes it difficult to create solutions under the existing scheme. Here, Stein, her next section talks about, this is a really critical point of the unit, that individual parcels of land under a planning scheme have to have a purpose, and the scheme needs to indicate the range of possible uses. So we'll introduce you to planning schemes, but basically planning schemes need to have certain elements. They need to say what will happen within an area. That's usually within a zone. This is a key term. So a planning scheme has to have a zone. The zone has a purpose, which is usually part of their descriptive title of the zone. There needs to be a map. So those zones need to be mapped, and it needs to be clear. And there needs to be clear lines on a map as to which zone you're in at any point. So a planning scheme sets out the name of the zone by reference to its marking on the zoning map. It states the objectives for that zone, the type of use and development permitted in that zone, the types that are prohibited. So planning schemes have permitted, discretionary and prohibited uses, and the standards. So through examples you'll get the gist of this, but this is really important in land use planning. So page 9, zoning is a little bit tricky in that sometimes people will, in applying for a development application, will actually be also applying for changes to the planning scheme because they need a different zoning, they need a different use. They're applying to do something that's not allowed. And so what you can do is apply for the development application, but at the same time apply for a change in the zoning, which would be a change in the planning scheme. So ultimately, there's an ideology behind zoning that is about trying to achieve these social goals. Increasingly, under new urbanism, this is often about mixed use, but this again in practice can be really difficult. So under a planning scheme, there's objectives, and there's a formal legal role for those objectives of a planning scheme, and they can be quite important when there's a dispute, and a judge might need to refer back to the objectives in making a decision about a land use dispute. Goals and objectives need to be expressed in a language that is general and outside the usual formula for legal instruments, and this again, creates a problem in terms of resolving individual disputes and what is meant by the objectives and what's consistent and what's not. They don't have the same authority as legal instruments. And yeah, so again, also policies, and this is something that I'm particularly interested in around active transport, for example, around healthy communities. They don't have the same legal status, but sometimes judges will refer to them in making decisions. They can be given some weight. Okay, page 11. Sometimes there's an emphasis in development controls from what's kind of intended under regulation because of political pressure. So sometimes aldermen will make a decision that's against what the council officer who has put in the report recommended. That's more to do with politics than it is kind of a straight reading of what is intended. And so anybody who's read a local paper reasonably consistently will have a very strong sense that community interest and making a fuss about something that you don't like is often really powerful, and aldermen are quite vulnerable to that kind of pressure. A sentence here that I particularly like: a legal system requires precision and planning profession that is concerned with conceptually difficult concepts don't join all that well. So this again goes back to an earlier point about the difficulty of meshing those overarching ideas with what's possible. A reference here back to those of you who've done the introductory unit. You should know what rational comprehensive planning is. The second part of this chapter, I'll skip over a fair chunk of it. It goes into detail about property rights and how, and particularly around issues of compensation when decisions are made. But again, this comes back to the kind of overarching idea about the tension between private property rights and public good. So she starts out here with an example of a tension around a large project to put in a supermarket on an area and people not necessarily liking that proposal. So council via the alderman might make a decision to permit something that, strictly speaking, probably shouldn't be. And again, sometimes changes are made to the planning scheme to allow for that. The developer is likely to face community opposition based on fears not reflected in the planning scheme, such as a belief that the area has a fragile sense of community or some other kind of loss of amenity that's not really captured, that aldermen may well take into account as a result of community pressure. There's another article in particular that I'll include in the readings that is about what's happening in outer Melbourne and how much land is being opened up there, and I guess the dangers of changing that outer zone from farm to residential and what can happen that might be desirable for the community as a whole. And so this section of the paper, you probably can skip over it. It's a lot of it's about compensation, either when area is downzoned and used for example, nature conservation and it's not developed, and also what happens when the reverse, and this is my note on the side, when the land is developed and the public loses an asset. Sometimes developers are required to compensate the public somehow by putting in a playground or some other infrastructure. So yeah, I haven't made that many notes in this section. I'll keep moving. Again, this goes back to principles about winners and losers and how you can get that balance between allowing somebody to do something and still retaining the kind of community benefit and the community ideals. Developers might need to put in infrastructure as part of being allowed to develop a land and create a profit from that. I hope this is not making you motion sick by scrolling down quickly. There might be a judgment made about the best use of land, and best might be different for different people. So yeah, all of this is quite a tricky juggle. The last section, there's some interesting views here around whether people have a right to views and a right to privacy and how that might be protected in planning. Increasingly, this is being taken into account, and conditions can be put on a permit to maintain views and maintain people's privacy. And a lot of this goes back to common sense, and when judges are looking to resolve disputes, they often fall back to what's reasonable and what's common sense. The last part of this chapter is about how planning and environmental law do and don't work together. Obviously, at a very high level, all decisions made in the implementation of the planning process have an effect on the physical environment. This often has a bit of baggage around it. This is, particularly in Tasmania, there's a lot of baggage around environmental process and litigation, greenies versus developers, particularly around forestry, but more generally that spills out into other areas of decision making. Those of you who have done KGA 381, Environmental Impact Assessment, will be quite familiar with this section. You might need to do an environmental effects report or an environmental management plan, depending on what you're proposing. So yeah, she makes the point here, but the marriage between planning and environmental law is pretty awkward. There are particular cases where you're prompted to come up with good environmental plans that are written by experts, such as botanical experts, but there are other cases where you might not have to do very much at all, even though you might be proposing quite a substantial change. So if you have done or are interested in doing EIA, we talk a lot about MCA. So this is the pollution control legislation that works in concert with LUPA. So where EIA has a focus on MCA, this unit has a focus on LUPA. Okay, yeah, this section here is about how regulation can find it very difficult to incorporate psychological harm, matters of culture, and quite intangible values. This is where some aspects of environmental impact assessment are relatively easy because weeds there or it's not, a threatened species is there or it's not, or it's in a certain abundance and it's quite measurable. A lot of these other values that we have are not particularly measurable, and that makes it really difficult. And again, while some of it's measurable, some of it is about larger concerns around climate change, around resource security and availability. So this section here is about, where do you draw the line on what you expect an individual developer to do? So in the case of the pulp mill proposal in Tassie, the developer wasn't expected to make any assessment of the effect of the wood supply that the pulp mill would have. There were much more direct assessment of the land and surrounding lands in terms of any kind of contamination of the marine environment, but there were a whole lot of things that they didn't have to do, and you've got to draw the line somewhere. Some of you might end up working in this field. I myself have worked as a botanical consultant providing reports for development applications. Fantastic, interesting work. Some of it involves mapping weeds under power lines, which might not be as thrilling as some, but I have also done some really interesting orchid surveys and other work, and it's quite a diverse set of things that you get to do. So some of you might end up in that field. There's some concluding comments here, I've nearly finished, about conservation planning more generally, about the dilemmas of setting aside land for environmental purposes and how the community generally is compensated, or an individual landowner is compensated in the case of private land. Some of this has been shifted to the market, so Tasmanian Land Conservancy, for example, actually acquires land and manages a land portfolio for the purposes of conservation. So there's quite a lot of talk in this second half of the paper around downzoning for the purposes of conserving land for biodiversity. And obviously this is pretty tricky, particularly as Stein points out here, in parts that are under a lot of pressure to be opened up for residential development. Makes it very difficult. Okay, that's the end of the chapter. I hope this is helpful, and yeah, feel free to go back to the actual chapter and read through, but I hope this is an interesting supplementation.